Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning. We are ready to hear arguments in our first case, Utah Physicians versus Diesel Power 20-40-43. We're ready to hear from the appellant.
Good morning, Your Honors. May it please the court, Cole Cannon on behalf of the appellant, all of the appellants except for Keaton Hoskins, who has resolved this case by settlement. It's a privilege to be here on this most important argument of my career, notwithstanding the fact we're here by electronic means. The significance of the moment is not lost on me. We're here to talk about some very important things. This issue is bigger than the Clean Air Act, the Clean Water Act, congressional intent, and in fact goes to the very heart of the Constitution of the United States of America, specifically Article 3 in standing. Specifically, the Lujan case and the standards that are indispensable, immutable, and irreducible. We think that if this case is affirmed, then those cases will in fact be disposed of, and that is not something that was intended by Congress. It's not something that's appropriate under constitutional jurisprudence. As the very wise Judge Shelby, who I find to be the most well-read trial judge and most intimidating one for that matter, well said that this case could benefit from some appellate review. And the reason for that is if this court upholds the lower court ruling and these doctors are able to bring a private citizen's action for these types of claims, then quite literally, everybody can sue anybody for any reason whatsoever. And even worse, they can seek attorney's fees. So what we're talking about today would be a very massive expansion of the Clean Air Act. And that's not what would be appropriate. And the reason the plaintiff cannot cite to one circuit court case that supports the proposition that a mobile source pollutant, such as in the case here, is because it hasn't existed. The Clean Air Act is no spring chicken. It's been around for 58 years. And there's not one case that at least I can find or that was cited in the brief that gives rise to a private right of action over a mobile source pollutant. I think
do you have any cases that can help us that are brought, as this one is, as a citizen's complaint under the Clean Air Act?
I think that there is some very good analogous case. One we cited is the Washington versus Bellin case. In that case, a group of concerned citizens sued the Washington Department of Ecology. The basis for their claim was that the Washington Department wrongly renewed a permit for 5 oil refineries. These are oil refineries that had been around for 20 years. Those are what we call point source polluters. They're fixtures, they don't move, in contrast to a mobile source, which would be like a truck that can go interstate and those sorts of things. The court said, in dismissing the plaintiff's cause of action, said that you do not, even though we're talking about 5 oil factories, much bigger than the harm at hand in my case, you do not have the redressability and the causality sufficient to meet Article 3 standing. That was the right result. The right result is that pollutants should have to make a meaningful contribution, which again is the whole jurisprudence of all the Clean Air Act history related to point source. Think factories, think big emitters, think haze clouds that are in people's backyards.
Well, if you put that requirement on it, can you ever have a citizen suit? I mean, that was one of the points that the district court made in this case.
It's a very astute point, Your Honor, and to address that, Article 3 is a threshold analysis that every litigant under the Constitution is required to walk through. We're not trying to gut the citizen suit provision under 7604 of the Clean Air Act. Citizen suits are a very important and well-respected part of our law. They're a very important part of our process of cleaning up the environment, and they've worked very well for countless years of point source and area source pollutants. They have not yet historically ever been used for mobile sources. And the reason for that is because federal agencies and state agencies are much better suited to enforce these sorts of things. No different than the federal government's ability to regulate interstate commerce, interstate banking, railways. Trucks, unlike power plants, can move over state boundaries, defeat parts that are shipped, like in this case, the 164 parts that were shipped inadvertently to other states. Was done through interstate commerce. The federal government, the EPA, the state regulatory agencies, even police officers have the right to ticket people when they are, driving polluting cars or their cars are too loud. But if we allow the scientifically insignificant or untraceable standard to be met by the claims here, then again, everybody can sue everybody, and it creates a situation an answer to the rhetorical question that Judge Shelby also asked below. He said, well, if I rule for UPHE, then can anyone with asthma in the Wasatch Front just sue anyone who drives a truck or your neighbor and bring them into federal court? I think the answer to that rhetorical question is a resounding yes. If this court ruling is affirmed, we will be expanding and creating a whole new area of Clean Air Act jurisprudence that allows neighbors to sue neighbors, and even worse, allows neighbors to sue non-neighbors. You might note in the file that my client was held liable for penalties for conduct that was outside the state of Utah, for parts that were shipped all the way to Florida, 2,000 miles away. It is undisputed we're talking about the Utah Physicians for a Healthy Environment, not the Floridian, not the South Carolinian, but my client nonetheless was held liable for penalties for conduct that happened out of state. And that runs afoul all the geographical limitations outlined in the case law, both Chevron Chemical, Crown Scent case, the Bellin case. Everybody has to still prove with concrete and particularized harm what they have done. To give a little bit of context here, which I think is important. My clients are famous, true. They have a show on Discovery Channel, which makes it look like they pump out lots of trucks. Over a 5-year period, we're talking about 31 trucks total, of which all of the ones that were given away in sweepstakes were given away out of state, not disputed, and only 3 of the trucks were given away or sold in Utah. 3 trucks and 9 parts is what we're talking about. 3 trucks, 9 parts stayed in the state of Utah that were sold here. Even if we go to the high water mark of 31 trucks and 88 part orders, we're not talking about a VW case. We're not talking about a big factory that pumps these things out on the daily. This is a very small number. In fact, these trucks, I wish I could show the court some pictures. These are very beautiful, big trucks that are better suited for monster truck shows and SEMA presentations. And they're not the type of truck you would see driving down the street a whole lot. And that's why it's undisputed. Our trucks over a period of 5 years only drove 4,200 miles. On a very busy month, I can personally drive 4,200 miles.
Counsel, let me drill down on something with you. What because it's the mobile source issue is interesting to me. What if you had some of your trucks were at a racetrack and my house was right next to it, and these trucks were over there, spewing out some diesel exhaust, and that exhaust was coming over and aggravating a medical condition I have. Do you think that I would have a concrete enough injury in that, being the next door neighbor, to have a cause of action against you?
Yes, Judge Carson, I think you do. I think that's a very good point. If this is run-of-the-mill tort law, what we're talking about is not expanding Section 7604 of the Clean Air Act, but if in your hypothetical, the noise was too loud, the decibel levels, the soot from the vehicles was staining the stucco on your house, or it caused an actual traceable scientific, not scientifically indiscernible, but actual harm to your lungs, for example, and you had medical experts to prove that, tort law is your remedy. And you can hail people in, and they do all the time. Any different than if my neighbor came and dumped toxic waste on my property, I would certainly have a cause of action.
We don't have to have probable cause in this case, do we?
No, I don't think probable cause is in.
Cause, yeah.
Yeah, I don't think. No, approximate cause, I believe, is required. Under Lujan, one of the criteria is there has to be a causal connection that's not interrupted by conduct of third parties. And we can talk briefly about third parties just to give further context. At most, we're talking about 0.0 tons of NOx gas over a period of 5 years. That's 40 pounds of emissions over 5 years. On a good day, if I eat my Wheaties, I can curl that much with one arm. So we're talking about an average of 8 pounds per year in a state that has 84,000 square miles of area. It has 3 million population base, 3 million registered vehicles, 5 coal burning plants, numerous oil refineries in the Wasatch Front. There is lots of contributing sources.
What's the threshold you would set? 500 pounds? At what point is there standing in your view?
Yeah, I think to be a meaningful contribution, it might have to rise to a level at least over, say, 5% might be a reasonable standard. Something that a scientist, and I'm certainly not the scientist, would be able to rationally tie or fairly trace into the Lausanne standard the conduct to the alleged harm. My speculation would be maybe that's 5% or greater. What we're talking about here, though, 40 pounds over a course of 5 years, we're talking about less than, I think the math is 1 billionth of the contributed air quality problems were caused by my client. I think this is important because let's expand this view to not just the Clean Air Act. If any litigant has any federal claims that they want to come in, they can always say, oh yeah, remember that Diesel brother case? There was only a 1/10000000th of a chance that their emissions actually caused physical harm or made its way into the lungs of the plaintiffs in that case, but that was enough for standing. And so we would be basically removing the whole standing barrier and allowing litigants to come into this case. The plaintiff in this case.
The only cases you have supporting that are greenhouse gas cases, is that right?
Yes, I believe this case is better analogized to greenhouse gas cases. Yes.
You don't have any other cases that support this minimum threshold, do you?
No, I don't. But the plaintiff.
Well, let me ask you about the greenhouse gases, because there, everybody in the world suffers the same effect. And the Supreme Court has made it, I think, reasonably clear that if you can't distinguish yourself from everybody else in the world, then you don't have standing. But here, the plaintiffs can distinguish themselves from others in the world because they're in this, the Wabash front area where the pollution exists. It's hard for me to see any precedent for the limitation you provide, you suggest for standing in that circumstance.
Yeah, it's a fair point. The atmosphere is a really big thing. By the same logic, we could say that somebody in Florida breathes the same atmospheric air in a quite literal sense. If I have any emissions come out of my tailpipe, then it ends up in the universe of air that all of us breathe. And so therefore, neighbors can sue neighbors for check engine lights. I can sue my neighbor down the street for missing catalytic converter. And remember, the Clean Air Act is not just a knowing violations, it's almost a strict liability statute as far as owning and operating these vehicles. And so the question is,
know or should have known.
There is a know or should have known in part of it, and in other parts, it's just basically if you own and operate, which opens up a very interesting issue. Many of these trucks, in fact, in our actual fact pattern, 17 of the trucks were purchased from an auction, already had delete parts on them. At auctions, you don't get oftentimes the opportunity to inspect the vehicle. You buy them, you sell them. Same goes for used car dealerships. They take a car and trade, they might spruce it up with a new paint job or something, and they resell it. We didn't tamper with 17 of these trucks in question. We just resold them innocently, and that's what happened. Yet we were held liable regardless of the fact they were sold, out of state and not in the jurisdictional grounds. So, Judge Hartz, you raised an interesting point. Is there some theoretical harm that's put into the atmosphere? Sure. But the standards of Lujan do not allow for that type of theoretical or abstract thing. The plaintiff has the burden to establish standing for every single cause of action, and meaningful contribution is a much better standard than mere contribution, because otherwise, because of the attorney's fees provision, you're going to have a deluge of new litigation. It's worth noting in this case itself, the plaintiff's counsel racked up $246,000 of attorney's fees prior to the complaint being filed, which pales in comparison to the actual attorney's fees that were incurred by the end of trial. I don't say that to cast any aspersions. I say that there's going to be a high incentive for attorneys to go pursue these types of cases against anybody when the state is much better positioned to do this. And that's why in the Massachusetts v. EPA case, the court made a point to say that state actors are unique and separate from private parties. State actors such as the EPA have a certain solicitude under the police powers to protect the health, well-being, and welfare of their people. It is a much lower threshold, again, the rational basis standard we all know and love, that's different and unique from the Lujan standard for private parties. Private parties must enter through the gates of Article 3, where state actors get to enter through the gates of Article 1 of the Constitution under the policing powers. This type of conduct is better regulated. Used car dealerships, used car auctions, mobile source pollutants that move state to state, parts being sold through internet distribution is better suited.
Let me ask you a question about attorney fees. Attorney fees haven't been assessed yet, have they?
They were assessed, and we filed an opposition to them, and they were reduced by about $500,000. I think that's
if a judge thinks that a lot of legal expenses are being incurred to deal with a minimal problem, the judge can reduce attorney fees. The judges have discretion to handle that, don't they?
They do, but I think that we're creating a whole new area of law, a whole new area of plaintiffs' counsel that's going to be very excited to be suing people over, maybe I got passed inappropriately on the freeway, and I want to file a lawsuit and send somebody to hail somebody to federal court. It's just a lot of new traffic that this and the other court systems in the union are not going to appreciate. I see that my time is running out here. I would just like to make one final comment on statutory standing. The EPA has rights that are under 7522 that are this big, that allow them to enforce defeat parts and those sorts of things. The citizens' rights under Section 7604 are much more narrowly defined, and the Fleshman case, which we, I think, appropriately briefed, outlined that case. If there's no other questions, Your Honors, then I'll yield my time.
Thank you. We're ready to hear from the appellee.
Good morning, Your Honors. Can you hear me?
Yes.
Thank you. My name is Reed Zars. May it please the court, I'm here representing the Utah Physicians for a Healthy Environment. And with me is George Hayes, my co-counsel, and I'd like to reserve several minutes for his time to the extent there are questions of the penalty. Your Honors, the airshed in the Salt Lake City area has been plagued by air pollution for a number of years. There have been many efforts, including those of my client, to improve the air quality by enforcing or requiring no drive days, to converting diesel buses to natural gas. In the light of all that, we have a group in that same airshed of men and companies making money, deliberately removing emission controls from diesel vehicles, installing defeat parts in diesel vehicles, selling parts to others selling defeat parts of others so that they can put their parts in their vehicles, and driving these high polluting vehicles in the airshed that's a very discreet airshed, as you may probably know, within the Salt Lake City area. Your Honors, Judge.
Counsel, let me ask you real fast. Is your opposing counsel says that your interpretation of the act is going to allow me to sue my neighbor for taking off his catalytic converter. Is that true? Under your theory, if I know my neighbor took off his catalytic converter to defeat the emission system, can I sue him under the Clean Air Act?
As a theoretical matter, Your Honor, I believe yes. That would be a violation of the Clean Air Act to the extent you had standing. That is, you had your personal injuries associated with the emissions coming off of a fully deleted vehicle. Yes, it seems.
Put me there in the Wasatch Valley. I'm a resident. I like to look at the mountains. I like to breathe clean air. And the only thing I can point to is that my neighbor took off his catalytic converter. But I can't prove specifically that any asthma or ailments that I have directly relate to my neighbor's catalytic converter being off. But I know the general condition in the Wasatch Valley is contributing to it. Do I have a citizen suit there?
Again, Your Honor, I believe in theory you do, as EPA would. And as you've seen, the state would. But the filing fee alone is $400 to bring one of these cases. If you look at the transaction costs to prosecute one of these cases, they're huge. So I would think Mr. Cannon's idea might be more practical. That is, you bring your tort case against them, but not one of these cases. These are heavy lifts that take quite a lot of time. And the reason we brought this one was the significance of the emissions from the Diesel brothers vehicles and their sort of public displays of them that were informing other people of how to do it. Understand, Your Honor, when we took one of these vehicles and had it tested, it showed that it was its emissions had increased 36 times what the emissions are of a stock vehicle, of a vehicle just coming out of the factory. All it takes then is these are super spreaders. And if you have just 2 to 3% of your fleet modified in this way, they are so disproportionately polluting that you double the emissions of the entire fleet.
Okay, so let me ask you this. So on your standing, you've alleged that the harms occurring in the Wasatch Valley. If you tried to expand that to a nationwide harm, do you still have standing? Or have you not tried to make that case?
Well, we did not try to make that case. And I think if you were arguing the case here, it is the impacts to a discrete, definable airshed. I'm sorry.
So let me stop you there for a minute. So, I mean, is it a fair statement that to the extent there are vehicles where the pollution is occurring out of this airshed as a result of vehicle sales and delete parts and sweepstakes, that those vehicles are off the table as far as harm?
Not exactly. That is, and it's under Judge Shelby's ruling, he said we were unable to recall those parts or recall those vehicles as part of our injunctive relief. But because the conduct occurred in the Wasatch Front and in Utah, and that conduct either caused injuries or threatened to cause injuries to the Utah plaintiffs, they were still subject to penalty. So we were trying to stop the conduct, but we were, and Judge Shelby ruled that we were unable to enjoin in a mandatory injunction the vehicles or have them returned and fixed or destroyed.
I'm sorry, Judge Hertz, go ahead.
No, go ahead, follow up.
Well, I was gonna say, it just seems inconsistent. I mean, we're looking at what the harm is, I think, as opposed to what the act is. And the harm is undisputedly, as to some of these vehicles and parts occurring outside the airshed that's the subject of your case. Because if we expand it, then you have no case because you can't particularize your harm. So you have to keep it narrowed down into the valley there. But at the same time, you want to recover penalties for harms that are occurring elsewhere. I just see an inconsistency. I'm wondering how we're supposed to get through that.
Well, let's look at one example, which is the sale of the parts. Yeah. They were selling parts to anyone who would buy them over the internet. Those parts are sold to people in Utah and outside of Utah. Those parts may be sold to someone in a neighboring or sister state in Wyoming that then drives that vehicle back to Utah. It's very difficult administratively to sort of divide up the conduct and say, well, some of this is prohibited if you sell within a zip code of Utah, but all of those outside of the zip codes in Utah, it's open season. So I think under the Constitution, to establish injury, one needs to show either a concrete injury or a concrete threatened injury. And it's the threatened injury that we believe is sufficient to at least support a penalization of those sales to then deter that practice that is, as a practical matter, again, very hard to just divide it up state by state or zip code by zip code.
Well, you don't have standing just because you're offended by a violation of law. You agree with that, don't you?
Yes, Your Honor.
So the argument by opposing counsel that there needs to be a meaningful contribution, I'm not aware of support for that theory. I think if there's been some pollution in the Wasatch Front area and you live there, you have standing with respect to that injury. But if something is shipped to Montana and so there's a threat of injury in the Wasatch Front, that seems a bit diluted to me. Do you have any case law regarding this type of threatened injury? Your theory would allow someone in Massachusetts to have brought this case because there's a threat that these vehicles will be driven in Massachusetts and pollute there.
Well,
that's attenuated. Go ahead.
No, fair enough, Your Honor. The violations at issue here all occurred in Utah. So we had standing.
That's not the basis of your standing. It's not that there was a statutory violation. Everybody can be offended by that. People who watch the show could be very offended by that. You've got to show some harm, or as you say, threatened harm, which maybe that's the basis of your standing, but I'd like some help on that if you have some cases on that.
Yes, I don't have a case on that because these are mobile sources that move around, obviously, and internet sales that can occur in and take place in one state and be transferred to another. But what we established was the violations and the conduct that was causing injuries within the state and that threatened to cause those injuries just by virtue of the fact that they're selling those parts in Utah and could be purchased by consumers in Utah.
And if someone in Utah purchases it, then you have a claim, you have standing. You can distinguish between these cases. I mean, there's not a difficult factual issue of determining where the part was delivered for use, is there?
It's not publicly available, Your Honor, but through discovery, you can, as we did in this case, find where the parts went to, how many they sold, and how many were illegal, like the EGR delete kits. So yes, but it does sort of balkanize the practice or the state of the law, where then you can move your operation to Wyoming and sell all the parts into Utah. It's problematic.
Let me ask you about a couple other issues, if I may. One has to do with the lottery and whether that was a sale. And in Utah law, as I understand it, you look at the person who won to determine whether the ticket was purchased. Do we know, with respect to the people who got the trucks through the lottery, whether they bought anything from the defendants to get the ticket or whether they just requested a lottery ticket? Do we have that information in the record?
Okay, I'm searching back. What I understand is that the people who bought equipment or parts or apparel on the website, every $5 they got a chance to win. Then there were other individuals who could just send in a free a postcard or a letter and get a chance to win. But I don't know. The percentage was obviously higher. They were making money on it, and so you had more sales than you had freebies. But
can you break it down for the specifics the specific winners in this case? Do you know whether for each winner, whether that person bought any tickets or made a purchase to get a ticket or got it without providing any consideration? Do you know that?
I don't know that. I remember from the videos where they have testimonials from the winners and they say, I bought the t-shirt and look, I won this truck. Okay. But I don't know between them all which ones bought and which ones didn't, Your Honor.
One other quick question. There were penalties imposed under both Utah statute and the federal statute. And you could read the federal statute as saying the fact that there were state penalties should be taken into consideration. Did the judge say anything about whether he was taking the Utah penalties into consideration when imposing the federal penalties?
Well, you're correct, Your Honor. He had an obligation to under the statute, and he looked at their ability to pay, the seriousness of the violation, and I don't recall him expressing specifically a distinction between the two types of violations, but that overall he weighed under this court's decision in Pound v. Aerosol the various factors that he was required to, but I don't remember him distinguishing between the two.
Any other questions from the panel? Thank you, counsel. We've had your arguments, both of you. We appreciate it. Case is submitted.
Thank you.
Thank you.
Our next case for argument is Dansie versus Union Pacific.
Good morning, Your Honors. Adam Hansen on behalf of Appellant Kelly Dansie. And may it please the court, this case concerns Union Pacific's refusal to provide any reasonable accommodation to its longstanding employee, Mr. Dansie, who suffers from AIDS and AIDS-related cancer. At the outset, I think it's important to clarify what Mr. Dansie was asking for. Whenever we hear about an employee who wants to take some time off of work, I think we naturally think of someone who works a 40-hour-a-week, regularly scheduled shift. Such an employee, of course, is only on duty 40 hours. He or she still has 128 non-working hours to do everything else in their life, including visit the doctor. This case could not be further from that prototypical scenario. Union Pacific is laying claim to Mr. Dansie's time 24 hours a day, 7 days a week, 365 days a year. So in a case like this, where Mr. Dansie is asking for a limited amount of time to see the doctor, we're really talking about just finding some time, any time in his life, in order for him to attend these important medical appointments. The district court committed a couple of overlapping errors on its reasonable accommodations analysis. And as this court is aware, there are really two sides to the reasonable accommodations coin. The first is what we might think of as a more substantive element. What was the request? Was it reasonable? Was the denial of the request reasonable, whether it was a ramp or a modified desk or something like that? But there's also a procedural component, which asks whether the employer unreasonably inhibited the search for a reasonable accommodation by failing to
Counsel, I'm getting static, and I think it's perhaps off of your mic that could be too close to you. There you go. Try that.
Is that better?
That is better.
Okay, Judge, if you hear it again, let me know and I can switch to my computer audio. I'm happy to do that. So picking up where I left off, what the district court held on the reasonable accommodation claim is that Mr. Dansie had impermissibly requested an unlimited amount of time off. That conclusion was both factually and legally flawed. Factually, the district court unreasonably constrained its analysis to a single document, essentially analogizing this case to a breach of contract case where the parole evidence rule might come into play. That's not how it works under the ADA. You look at all relevant evidence of the request, and when you look at the other evidence in the record here, including emails and voicemails, two things are very clear. First of all, Mr. Dansie was only asking for up to 5 days off a month, again, in this total denominator of time. And secondly, Mr. Dansie,
let me ask you about that, and then I'll let you continue. But
sure.
So you say he was only asking for 5 days off. The the request, at least on paper, was 5 days off plus as much other times as he needed in his discretion, depending on how he was feeling and such. So that's not 5 days. That's, reasonably construed as being more than 5 days. So where did he limit this and say, I'll give it up for 5 days only?
Sure. Well, it was limited through conversations principally with, for example, Terry Owens, who's Union Pacific's Director of Disability Management. There's a voicemail, there's an email that talks about these things. But let me make the second point, which is...
Well, tell me what they say, though. What do they say? What's the voicemail say? Does it say, I'll give up on the discretionary stuff, I only want 5 days?
Well, he never... I think this leads to the direct... I do want to answer this question based on the facts of the case. What happened next is really important because Mr. Dansie got a call from Union Pacific's disability management group and said, congratulations, your request is granted. So Mr. Dansie, was never put in a position to answer the question that you just posed, Judge Carson. He was completely head faked here because had somebody said, this is problematic, appears to be this fine print in this one form that suggests that it could be 5 days, but it could be longer, that's problematic. What do you say? Can we specifically limit it to 5 days? He would have said, absolutely, let's limit it to 5 days.
So this is a summary judgment, right, on this issue?
Yes, it is. Cross motion.
So we at this point, in your view, we don't know what time he asked for. We don't know what the Union Pacific said in response to what he asked for. And maybe my curiosity is exactly what is the leave time policy of Union Pacific? How much time can a person get off in his position?
Yes, so it's a cross motion for summary judgment case. And that's really the last part of your question is really a crucial part of the analysis because no one is claiming that Union Pacific's own policy requires someone to literally be available 24/7, 365. The problem is Union Pacific's policy does not say with extreme specificity how much time an employee can, it's called laying off, right? This is essentially indicating unavailability for duty. But the policy says three things that all cut in Mr. Dansie's favor. Number one, it says that reasonable layoffs are permitted. Number two, it says that layoffs are permitted for bona fide illnesses as long as they're documented. And number three, the policy says crystal clear that employees can use their paid time off. Mr. Dansie had been working there for 10 years, so he had accrued enough paid time off, almost a month's worth, to cover all of these appointments. And so, this isn't a breach of contract case, this is an ADA case, but the two are very related. When an employer is refusing to follow even its own policies with respect to leave, it's pretty difficult for the employer to turn around and say that the request is unreasonable.
So at bottom, do we know exactly what accommodation he wanted? It's back to Judge Carson's question. Was he asking for 5 days? Was he asking for an unlimited amount of time off?
He was asking for 5 days. And if I could point the panel to one other thing in the record, Mr. Dansie was terminated and ultimately reinstated under his CBA. And under that proceeding, they reached an accommodation of 3 days per month. And Mr. Dansie is working there today at 3 days per month. So this idea that no accommodation was possible is just totally not supported by the record. And this really dovetails.
So if he asked for accommodation, which I guess we assume that, was there any interaction, any discussion, under our case, Smith v. Midland Brake, that's required, of course. Was there any discussion about accommodation and what other positions or accommodations could be made? So
here's the discussion in a nutshell. Mr. Dansie makes the request. Ms. Owens says, please have your doctor fill out this form. He does that. She says, well, there's an issue with this one piece. It's not super relevant. Have your doctor fill it out a second time. He does that. And then 2 weeks later, Mr. Dansie receives a call and says, congratulations, your request for accommodation has been granted. And that's from Kim Floyd. It's a telephone call, so it's not recorded, but the date, the time, the person are all identified in the record. And then essentially what happens after that is this bizarro scenario where the company headquarters in Omaha is doing one thing and the local supervisors on the ground are doing something completely different. They are doing this progression of progressive discipline, and it becomes clear to Mr. Dansie that they're trying to terminate him. And so he eventually calls back, Ms. Owens, the person in charge in Omaha, and says, "What is going on here?" And she just goes limp at that point and says, "I'm not going to get involved." So that's the trajectory. And the ultimate point I wanted to make is this is, I think, an even stronger failure to participate in the reasonable in the interactive process case than it is on the substance. Because it's one thing if an employee says, and this goes directly to Judge Carson's question, "No, this is it. I'm standing on this request. It's this way or the highway." At that point, the only thing for the court to determine or the jury to determine is whether the request is substantively reasonable. But for an employer to say, "Yes, your request is granted as written," and then turn around and fire the employee and say, "Well, we've identified a technical violation with your request," and use that as a shield in litigation, it really completely undermines both the text and the purpose of the Americans with Disabilities Act. It gives Union Pacific an advantage that an employer who participates in good faith would never have received. And of course, this isn't a mere process violation. It's just a way in which the process breaks down. It inhibits the identification of what basically everyone agrees were a number of accommodations that were available.
Yeah. On what basis did the district court reject the argument you just made, saying that he was granted the request and then fired for having an imprecise request?
Right. So the district court's order was read into the record. The discussion on this part was extremely truncated. So to my memory, and we'll have to go back and look at the record, but to my memory, the district court just said no reasonable accommodation was possible. And of course, this is a second prong, Judge Hartz. There is sort of a no harm, no foul rule. If the company fails in its duties under the interactive process, but ultimately can show in litigation, not only was whatever request was made not reasonable, but no reasonable accommodation was even possible in the total universe, then the employer wins. So it seems like that's what the district court said. And other than one sentence in its response brief in this litigation, I mean, Union Pacific, it's basically an indefensible point, right? I mean, he's working there now under the same accommodation. He worked there for 10 years. He could have been transferred to another position. I mean, the idea that there's simply no possible accommodation.
I thought he admitted that there were no other positions that he would be qualified, that he could handle.
No.
He didn't say that in the position?
He didn't. I mean, the testimony was a little muddled, not just from him, but from Ms. Owens as well. First of all, she couldn't even remember if she had actually had the conversation. So she was sort of hypothesizing.
Yeah, I am asking what he said. I thought
Sure.
he said there are no other positions that he could fill.
I think
What did he say?
I don't have the text in front of me, so I'm going to have to paraphrase, and I'll just stand on the record. Of course, it speaks for itself, but I think he understood that there were no other positions, maybe at his precise location in Utah, that were on-call conductor positions.
Well, is it up to the plaintiff here seeking ADA accommodation to come up with potential positions that would accommodate him?
Well, it's partly the plaintiff's position. It's partly the plaintiff's job, but it's partly the employer's job. I mean, there's no real technical way to reduce down this interactive process. What it boils down to is, look, there's information that is uniquely in the purview of the plaintiff. There's information that's uniquely in the purview of the employer, and they need to sit down at the table. And we've all seen lots of cases where, maybe there's a good faith debate about the ultimate result, but you look at it and you say, both sides did their job. They negotiated in good faith. They explained themselves. If a request was rejected, it was explained. It was put in writing. Frankly, this is the first case I've ever seen where a request was granted and then, I guess secretly denied, and then the employer turned around to terminate the employee. And that's just simply not permitted under the Americans with Disabilities Act. Briefly, with respect to the relief we're seeking, and then I do want to touch on this jury question issue. We do believe we are entitled to judgment as a matter of law on the Americans with Disabilities Act. But of course, if this court disagrees, the middle option is to have that issue tried if the court believes that there are questions of fact. On the FMLA issue, if I may. This case was tried on the theory that the company terminated Mr. Dansie essentially to avoid him requalifying for FMLA leave. And the jury asked a question which was a very intelligent question, essentially whether Mr. Dansie even had rights to exercise under the FMLA. And I hadn't researched this. I had to look it up myself. It turns out the answer is yes. The problem was that this was a predicate legal question that had already been resolved by the court and was not the specific factual question that the jury was asked to decide. So in other words, the jury was asked to decide whether the termination of Mr. Dansie was motivated in any way by the exercise of his FMLA rights. What the jury needed to know, and what the original jury instructions didn't say, what the jury wanted to know, was does the FMLA just protect people who have it, who want to use it, or does the FMLA also protect people who are trying to gain FMLA rights? And the law is clear. It covers the latter just as much as the former. And so the analogy we make in our reply brief is it would be just like a breach of contract case where the jury is just supposed to decide consideration, but it asks a question about offer or acceptance. It's very normal that jury instructions don't necessarily have to negate or explain away everything the jury is not required to decide. But once the jury puts that in issue and asks what is, in this case, was a very intelligent question about a predicate matter that was not the jury's to decide, then it is up to the judge to resolve it.
What if the jury is astute and comes up with a new theory of liability that's permissible under the statute, but it wasn't presented, it wasn't argued by the plaintiff? It's hardly fair to a defendant to allow a new theory to be the basis of a verdict. When that happens, the jury may be interested in it, but that can't be a basis of a verdict, can it?
I agree wholeheartedly, but that's different from what we have here. This wasn't about a unique theory of liability. This was the theory of liability. The jury was only asking about a predicate legal question about what does it mean to have the protections of the FMLA. And so this was the heartland of the theory. It was just something that wasn't in the jury's purview. I see that I'm out of time, so I will ask the court to reverse and remand, as I've asked, unless the court has any further questions. All right, I thank the court for its time.
Thank you. Ready to hear from the appellee.
Thank you, Your Honor. Chris Hedekin on behalf of the appellee, Union Pacific Railroad. I'm pleased to be before the court here today. Judge Shelby correctly ruled that Union Pacific was entitled to summary judgment on the failure to accommodate claim, given the request for an unlimited amount of time off for a job that the plaintiff admitted required physical attendance. There's few jobs that are more clearly require a conductor because it's both illegal and a CPA.
Well, the requirements, as I understood, as far as attendance, allowed for frequent layoffs, and we don't have a definition of what frequent means, do we?
Judge, there's not a specific definition of frequent layoff. The policy that exists outlines for these individuals, and it's consistent with what's agreed with the union, is applied to Mr. Dansie the same way it was applied to everyone else. He does have the opportunity to have layoffs. There are a certain amount of layoffs that are allowed. There's also the opportunity, even if you don't have those available, to ask for it. And if the needs of the railroad are met, they will allow you to take that time off. The problem is that if they don't have a sufficient number of conductors to be able to cover that particular locomotive, they will need to deny you that obligation or that request. We did put evidence within the record for Judge Shelby of others who were held to the same standard, given absences for the same number of absences, in some cases for even fewer absences than Mr. Dansie had.
Had the plaintiff been accommodated in the past to permit him to attend medical appointments?
Not under the ADA. He had, prior to his first termination, Judge, he had been on FMLA, which did provide an intermittent obligation or intermittent right to leave. And he had used that for a number of years. Once he lost his position due to the safety violation.
And so the trains ran in spite of that, right? When he had that opportunity under the FMLA.
It's true, Judge. We ran our trains as best we could. It doesn't change both what he testified to and what others testified to, which is that there are many circumstances in which those trains are delayed because you have no conductors and no locomotive engineers available to be able to run those trains.
Well, was he asking, in your view, for an indefinite amount of time off?
No question about it, Your Honor, because there was no specific limitation placed upon the term of his limitation. It wasn't just that he failed to tell us how long he'd need it. He never indicated how long he would need it for his impairment. And the fact is...
Did anyone ask him?
Ask him how long he would need it? Yeah, that's right within the form. The information that was placed within there, though, was that he would need 5 days off a week.
Any personal interaction aside from the form?
I apologize, Judge, I didn't hear you.
Any personal interaction from the railroad with the plaintiff beyond the information that's on the face of the form?
Yes, Terry Owens, who's an individual within a position that was specifically for the purpose of trying to navigate the ADA as well as other medical employment issues, worked with him and spoke with him on that particular document.
Now, the opposing counsel said that Terry actually approved his request, or somebody in the local office, and if that was the case, it would be a little disconcerting to then be fired after you're granted the request.
Correct. And Judge, that fact is, in my humble opinion, a manufactured argument to forestall summary judgment. The complaint that was filed by Mr. Dansie in both paragraph 16 and 23 said his accommodation was denied. He never alleged within his complaint that his accommodation had been granted. In his summary judgment, his offensive filing, which was filed 2 days before ours, he never said in his undisputed facts that an accommodation had been granted to him and that he would have looked for other positions. He never made that argument at all. He only raised this argument in an affidavit which contradicted his deposition testimony in opposition to our motion for summary judgment, which the court had no obligation on summary judgment to credit, particularly given the judicial admission within the complaint that his accommodation had been denied. Going back to your question, Judge Hart, on...
Is that procedural question? You can, I think our law is that you can submit an affidavit that's contrary to your deposition, and it has to be credited for summary judgment purposes if you explain why you didn't mention it earlier. Was there any explanation in the affidavit of, I forgot about this, or anything like that?
None whatsoever, Your Honor. There was no such explanation, and nor could there be, because this was not the theory on which this case was advanced. And this is why Judge Shelby granted summary judgment. He said specifically, and I was on the call with him when he announced and read his opinion that was transcribed into the record. He said specifically, look, you testified that you knew about all the positions and that no other position was available for you that would have been suitable to accommodate your position. In addition, he said, you've had substantial time during discovery to present evidence of what positions would have been available if you couldn't, given that this accommodation could not be granted. And you did not put any such evidence into the record. There is no such evidence in the record to that effect, that there were any other jobs back at the time that summary judgment was ruled upon, as is required by this court's en-banc decision.
Well, is that a responsibility of the plaintiff to come up with the positions and tell the employer, hey, I have researched your books to find out how many positions you have and what I would be qualified to do? Is that the plaintiff's responsibility?
In the context of the interactive process, they have a shared responsibility to identify effective accommodations, Judge. That's different than the summary judgment posture. What I'm pointing out is that if their theory was, hey, I was told I had an accommodation, so I didn't look for anything else. If that was in fact the real theory, then they would have gathered discovery from us that showed that there were positions available, marshaled their evidence to substantiate and meet their burden of proving that we violated the ADA in failing to provide an accommodation. They never asked for that information. They never sought it. The council never did, because that was not their theory. And that evidence was not in the record. And Judge Shelby then can't
tell me what you think their theory was.
Their theory was that they felt that we were just simply unreasonable in denying the accommodation, that the accommodation was not unreasonable and that we could not substantiate an undue hardship.
Okay.
Most of their summary judgment briefing is devoted to this isn't an undue hardship or we can't meet that burden of proof. And so that was where we're at in this case, is Judge Shelby said, hey, you have not shown any evidence here of where this accommodation was possible, of what positions. The assertion that 2 years after the fact, when he was reinstated yet again by the PLB, that he was then accommodated is also not relevant record evidence, because it only comes to light in the context of a request for reconsideration, which the court denied. And in addition...
Well, but doesn't that tell us that there was a position that he could hold and could be accommodated?
It doesn't, Judge, because the accommodation request is now 2 years later. The condition, there's no evidence...
So that position that he's now occupying was not in existence before?
There was no evidence that that position existed or that such position was available. Plus, the accommodation request 2 years later is different. It's not the same request that was made. And so, again, there was nothing...
How is it different?
How is what different?
How his accommodation...
He asked for less time. He's asked for 3. My recollection, Judge, is that he's asking for 3 days. And he submitted that. He submitted it twice. Keep in mind that in this case, this original request, Mr. Dansie's testimony was that he drafted the accommodation request both times. He gave it to his doctor. His doctor signed it without change. So this was exactly what he knew he needed. And when he said, hey, I might need additional time off without notice, those are Kelly Dansie's words. And then his FMLA request, which he subsequently submits, is also prepared by him. It says essentially the same thing, but has a little more information on it. So the bottom line is Judge Shelby made the correct determination here. This was not a plausible claim for relief. That has not been changed. That standard has not been changed by XB Stoll, as asserted by Dansie's counsel. In fact, it was applied subsequently, that standard in Padilla v. Mnuchin, a subsequent case. And he said this wasn't a plausible claim for relief. And in addition, there's no failure of the interactive process because there's no record evidence that there was another job that would have been able to accommodate you. Had that evidence...
Is that something that the employer presented to the plaintiff, these other jobs?
At the time, Judge, we denied, so this is where on our record, we denied his summary judge, or we denied his accommodation request just as he concedes in his complaint. So we denied it, and there was not a subsequent follow-up from him. There was testimony from Terry Owen that she did have an inquiry of him about whether he would be interested in other positions, but he did not pursue that. Now, that there's a conflict in what's being presented now, given that affidavit. But again, on this record...
Well, did she express to him what other positions?
She discussed talking with him about pursuing other positions, but he said he was not interested. The same way he testified to me when I took his deposition, and he said I asked him, why didn't you pursue any other positions? Because as union members, independent of the ADA, and I'm not suggesting to you, Judge, that shifts the burden on him to take care of, but it is a relevant fact. In the union, you can just look and see what jobs are available, and if you think they're going to work for you, you go ahead and bid for them. But he told me nothing else would work for me. I didn't want anything else, and I should get this. And so when we look at the record that Judge Shelby had, the opportunity of Mr. Dansie's counsel to prepare and ask for and submit evidence of these other positions, it's a record that fully supports the summary judgment.
The plaintiff here also says that the employer refused to let him use his paid leave days. Is that true?
That's not true, Judge. But what he's referring to is what I discussed a little earlier, which is you can ask for time off, which will be paid. And if we do not, our needs do not require you at the railroad that particular day, then you can take a paid day off. And he indicated that he did take some of those. And he also indicated that I would be denied if the needs of the railroad did not allow me to.
Well, did he specifically in any instance ask for a paid day off to attend medical appointments and was refused?
He would ask for time off, in other words, the way it works, it's not a specific request for time off for medical.
Yes. The
request is, hey, when we call you, we need you there. And he then responds and says, I want to lay off. They say, no, we can't give you that time off. What he would do first is say, I take a paid day off. We'd grant it if we could, but if we couldn't, we'd deny it. Then he would lay off and say, I'm not able to come today. I'd like to spend just a little time on the FMLA issue. In that particular issue, the judge correctly responded to the jury's question as he did. There was one issue in this case, and that was simply the jury was asked to decide, has Union Pacific carried its burden of proving that it would have terminated Mr. Dansie regardless of his use or attempted use of the FMLA. That's the sole issue. And the jury was also told that it is unlawful for any employer to interfere with, restrain, or deny the exercise or the attempt to exercise any right by the FMLA. In this particular circumstance, there was no objection to those instructions. The judge responded and said, you have the information in your instructions, just look at them as a whole. And that's what the jury did and came up with their determination that we had met our burden to prove.
Did the instructions tell the jury that he was eligible for FMLA benefits?
Judge, the instructions did not say that he was eligible for FMLA benefits, but it was in record evidence that he had at the trial that he did not, he didn't have FMLA up until a certain point, but that it was granted on April 10th prior to his termination.
Had the district court made that legal ruling prior to the submission of the case to the jury?
He had, in essence, the reason he instructed as he did, Judge, is because he made the determination that the prima facie case had been met, that he had the standing.
And was the jury informed of those findings, those legal conclusions that the court had determined?
No, the jury was told that it did about the question, the only question that it needed to decide. And in this sense, Judge, essentially the instruction presumed that he had made a request for FMLA or attempt to use FMLA. And so that's established. It's really no different than the same decision defense.
Well, but did the jury know it was established?
By the fact that
that's the whole point of their question.
Judge, they knew that his use, that by the instruction that the use of FMLA or the attempted use of FMLA was protected. And so by very definition, the attempt to use FMLA, it means that if you're trying to use it, whether you have it or not, that you have the right to, you should be free from termination in those circumstances. And so once they were asked the question, do you conclude that because he asked for FMLA, either to attempt to use it or to actually use his FMLA rights, do you think he would have been fired regardless? And the answer to that question was, yes, we think regardless of his attempt to use FMLA or actual use of FMLA, that did not affect the outcome. He was fired regardless.
Thank you.
I've gone over my time, Your Honor, but I would be very glad to answer any other questions.
Thank you.
Thank you.
Do we have rebuttal time? No, we don't. Okay. Thank you both for your arguments this morning. The case is submitted.
Thank you.
Our next case for argument is Leyva versus Robbins. We are ready to hear from the appellant.
Thank you, Judge. If it please the court, my name is Robert Sykes. I want to talk for a moment about the importance of fences. 10 years ago, a young client of mine, a young woman, was southbound on I-15. I apologize for my cough. About 60 miles north of Salt Lake in a rural area. And she hit a large bull on the road. Let me just turn this to... Go. They sent these
now
to
you're in the courtroom. That's lovely. Okay.
Well, they
It
sent these
doesn't
to
really matter. We'd really like to hear from you.
Okay. But she hit a large bull on the road and it destroyed her car and gave her a significant brain injury. We got out there right away and found out that the fence had not been maintained. Now, fences in rural areas prevent serious injury and death. We're talking today about qualified immunity and metaphorical fences. It's an important doctrine. It's a robust doctrine. It protects legitimate police functions. Fences are rules. And without rules for qualified immunity bulls get on the road. They can harm innocents and they can damage constitutional rights. Rule number one, qualified immunity is only for police work, to protect their discretionary functions. In Elder versus Holloway, U.S. Supreme Court said that the central purpose of qualified immunity was, quote, to protect them from undue interference with their duties, citing Harlow versus Fitzgerald. In Butts versus Economy, the U.S. Supreme Court said it doesn't protect actions, quote, manifestly beyond their line of duty. This case in Furchbach versus Southwest Airlines, this court said that the officers must act in furtherance of legitimate law enforcement interests. It also said there's no qualified immunity if a prank in this case furthers must act in furtherance of legitimate law enforcement interests, and there's no qualified immunity for a prank that furthers no public interest. Now, in this case, Trooper Robbins, his own words, said that the stop was a joke between friends. On the harassment, he said, I thought she welcomed it. He was demoted by his own agency. He was removed from the assignment, demoted from sergeant down to trooper, 2 levels. And this case, this court said in Valverde versus Dodge in 2020, Judge Hartz and Carson were on that panel, talked about the calculus of reasonableness for qualified immunity, split-second judgments, tense, uncertain, rapidly evolving situations. You don't have that here, and you don't need qualified immunity to protect an officer from personal flirtation and illegal stops.
Let me see if I understand what you're arguing here. Are you arguing that we don't even need to do a qualified immunity analysis, i.e., determine whether there was a violation of a constitutional right, whether it was clearly established, because there's no qualified immunity here because it wasn't a police function?
That's what I'm saying, Judge.
Okay.
And that's what you've said. That's what this court has said in the Furchbach case.
Well, if we don't go there, can we go back to the requirements that Judge Carson has just voiced? That is what is your violation of constitutional law?
Okay.
And what clearly established law do you have to support it?
Good question. The violation of constitutional law with the traffic stop first, okay? By the way, I'd like to reserve 3 minutes if I could.
Time is your own. Go ahead.
All right, thank you. The traffic stop, we have 50 years at least of traffic stop law. It says that you cannot pull somebody over unless you have reasonable articulable suspicion, okay? And that's pretty clear in the law. As far as the sexual harassment, the ongoing sexual harassment, that's pretty clear too. A public official, an officer in this case, cannot harass a private citizen.
So the constitutional violation on the first one is the Fourth Amendment.
Fourth Amendment and 14th.
And the 14th Amendment, and
Right.
the 14th Amendment on the second?
On the second one.
Okay.
Yeah, on the sexual harassment, 14th Amendment. Now, I hope I've answered your question, Judge Carson. The second fence I want to talk about is the no scavenger hunt fence. Now, the U.S. Supreme Court has been very clear in Hope versus Peltzer that, quote, even novel factual circumstances, okay, can be the basis of liability. They, quote, we expressly rejected a requirement that previous cases be fundamentally similar. This circuit in Casey versus City of Federal Heights said the Hope decision shifted the qualified immunity analysis from a scavenger hunt for prior cases with precisely the same facts. Okay. Now, the trial court in this case found that the stop violated the Fourth Amendment. Very clear. I put that in the brief. He found that a reasonable jury could find that Heather was sexually harassed. Okay. But then he sent us on a scavenger hunt. And on page 23 of his decision, he wanted us to find, for example, cases with, quote, pre-existing and ongoing relationship between the officer and the citizen, and an exchange of text messages concerning the stop, both before and after the stop, and a different location for the stop than initially identified.
Let's talk about the stop. Let's talk about the stop first.
Okay.
Did she consent to the stop at issue?
No.
Does she say in her complaint that she just did not consent to it?
She did. And their position was that a text exchange 2 hours before, okay, on I-15 in Utah County, gave him that he thought that she had consented, and she didn't respond to the last text message. I put that in the brief. And she goes somewhere else, does her business, and comes back 2 hours later, Your Honors, 2 hours later, on a different road, on a different location. And she's scared to death because the officer turns on his lights. She doesn't know who it is. She has to pull over. She can't just ignore flashing lights. And then she said she was, quote, creeped out when he showed up. How did he know where she was? She's a single woman, single mother at home with 3 children. She's going home, and this officer pulls her over for no reason, just to flirt. Now that was his.
Let me ask you a question about the text messages and the consent.
Yes.
Does she anywhere in that text string say, yes, pull me over, I'm looking forward to seeing you, be great if you pull me over? I mean, it seems to me at best the text string establishes that she didn't respond to him saying, I'm going to pull you over.
Yeah, she didn't respond, Judge. You're absolutely right. Absolutely right. And she didn't respond. And the problem, and no, she didn't welcome it. She didn't want it. The problem with this argument, when I go on a scavenger hunt, it allows bulls on the interstate at night. It validates harassers and rapists' dream excuse. She welcomed it. It validates subjectivity. I thought she consented, okay? Every woman, if this decision comes down the way the defense wants it, every woman will be at greater risk for harassment and abuse, and worse. And it engenders great disrespect for the law.
So is it your position that what we have to do is find that there's another case that says you can't pull someone over without reasonable suspicion, or it's a constitutional violation, and that if we have that case, that it's clearly established?
That was the trial court's position. The trial court, as I read you a minute ago, they wanted a case where there's an ongoing relationship between the officer of some kind and exchange of text messages. That's on page 23. They wanted the exact factual situation.
I'm asking you sort of the opposite. are you saying all we need to have is a case that says that a police officer can't pull someone over without reasonable suspicion?
No, that's far too general. What I'm saying is that the case law has to give fair warning. Fair warning.
Well, what's your
case? Apparent. And there are lots of cases that say that. For example, you said in 2020, State of Smart versus City of Wichita, our analysis is not a scavenger hunt for prior cases with precisely the same facts. A prior case need not be exactly parallel to the conduct here before the officials to have been on notice of clearly established law. Okay.
Right. So my question
that's crucial.
Is, what case do you have that put them on notice?
Okay. On the traffic stop, Botero Ospina. I quoted that in the brief. Okay. It said, and let me just grab that real quickly. If I can.
You can just, you're running out of time here. You can just tell me the case.
No, but that said, you can't pull somebody over, and your subjective reasons don't matter. They don't matter. Okay, and that case was argued, and on the sexual harassment Johnson versus Martin 10th Circuit case.
Let me focus, since we were almost out of time. I want to focus on the sexual harassment outside of the traffic stop. So if you have two state employees working in an office together and one sexually harasses the other, is that a violation of the Constitution?
Well, it could be. That's not this case. This case focuses, but it certainly could be, especially if the state knew about it and tolerated it. That certainly would be.
Well, I'm not talking about that. I'm talking about just that would be for a offensive work environment, hostile work environment. But I think our cases indicate that if it's just one employee harassing another, there's not a violation unless there's some sort of supervisory relationship.
Right. Right.
Yeah. So it's a matter. So what's essential here, it seems to me, is that there be some sort of extra power, extra authority conferred on the harasser by state law. And that would be the case with the traffic stop. But I don't understand how it is with the other activity that you consider sexual harassment. He's not acting in that circumstance, that harassment, he's not acting as a police officer with law enforcement powers. He's acting as a contractor. It's two people who are one's the provider of services and one's a purchaser of services. And that's their relationship there. And I'm not aware of any cases saying, maybe you can help me on this, saying that provides the power imbalance that can justify, that can support a constitutional claim for sex harassment.
I respectfully disagree, Judge, with the way you phrased that. He has power over her. He runs the heavy-duty towing rotation. She's a secretary. Her job is to make sure they get their fair share of referrals. And he can cut them off and threaten to do it. That's the power he had.
Well, but that's power only through contract. She could also say, we're not going to provide you any towing services because you're a jerk. And that would not help him in his job at all. They wouldn't get
these are $25,000 tows. It's important. It's a very valuable contract to have.
Yeah. And it's also, and they cost a lot because they're really important.
That's right.
When you have a contract relationship, we generally assume that there's bargaining power on each side. So
I only have a few more seconds on one.
But the question is whether you have any cases where the authority is that conferred by contract. Every case I saw was either a supervisor of the employee or someone who had law enforcement power, could deny a license or something like that.
Johnson versus Martin.
Do you have any cases in which the relationship involved is a contract relationship?
Well, I'm not quite sure what you mean by contract relationship. The state supervised this towing. There was a contract, yes, but the state supervised, Your Honor, supervised the heavy-duty towing rotation. Let me just close with
to the towing company was just a contract relationship, was it not?
I think I cited cases that do that, but in closing, let me just say,
I don't think you did.
Jones versus Hunt.
Okay.
I'm sorry, I didn't get that.
I didn't see any you cited, but
they're in. I think it's point 2, about 27 to 40 pages, 27 to 40. But here's what Jones versus Hunt said about these cases. Implicit in the court's reasoning is the recognition that officials committing outrageous yet sui generis constitutional violations ought not to shield their behavior behind qualified immunity simply because another official has not previously had the audacity to commit a similar transgression. And that's what we've got here. In that case, they hauled some little girl into an office at school and tried to persuade her to switch custody, and there were no cases on that. And I would just close by saying one more thing. As you said in Bond versus Tahlequah City on December 1, 2020, Judge McHugh said, look, you could look at this different ways, okay? But there are questions of fact where a reasonable jury could differ on how to view these facts. And at the very least, a reasonable jury could differ on whether there was consent, okay? And so I urge you, I think it's important for the women of our country and our circuit to have a good, strong opinion. You cannot sexually harass a woman the way this officer did.
Thank you. Thank you. We have your argument.
Thank you. May it please the court, Cliff Peterson for Blaine Robbins. I would first begin by noting that this is Leyva's burden to show that the law was clearly established. And if I understood counsel a moment ago conceded that it was not enough for someone just to cite case law saying you have to have probable cause to initiate a traffic stop. He said that's not enough. That's exactly what he gave the district court. He just gave general Hornbook principles about probable cause to initiate a traffic stop. That's what he's done now on appeal. We submit that he's failed to meet his heavy burden to show that the law was in fact clearly established.
Well, isn't it really that simple? She's pulled over by this patrolman at night with his lights. She doesn't know it's him. It's not any place that they had talked about potentially is doing that. And he's pulling her over without reasonable suspicion, probable cause, or anything.
Well,
is that a flat out Fourth Amendment violation?
Well, as the district court correctly noted, the law was not clearly established that consent cannot play into this analysis. In the midst of a back and forth. She does not
concede consent. She does not concede that fact.
Well, I know that she tries to.
You're looking at this clearly established law question as though consent were a part of the question.
Well, consent is part of the analysis, as the district court said, because if let's change the facts just a little. Let's say the text said, come pull me, she says, come pull me over. A reasonable officer, it would not be obvious. There's no case putting that officer on notice that he could not pull her over in response to a direct request, an explicit request, please pull me over. I want to see you. Let's say she says that. What we're saying here is that the facts aren't that far removed. She may retcon the conversation, but objectively, she concedes that the text messages speak for themselves. They say what they say, and that is, he says, I'll come. She says, I have a document. He says, can you give me the document? She says, stand by, I'm on the freeway. He says, I'll pull you over. She gives him the mile marker number. She tells him what color car she is. And critically, the next day, he says, I thought you were sore at me for pulling you over. And she says, no. I think in the context of all of these circumstances, she consented to and a reasonable officer would have seen that as consent to pull her over. And most importantly, there's not a case putting this beyond debate that every reasonable officer in the midst of this back and forth and this ongoing relationship would have known beyond debate that you could not consent to a traffic stop. So we think the district court got it right.
Let me stop you for a minute. So you concede there was no reasonable suspicion or probable cause to pull her over.
Well, there was a cracked windshield, and that's in the record. But in his deposition, he said that wasn't the reason. He pulled her over because he thought she consented.
Yeah, he said it was a joke.
Yeah, well, Joe brought on by her consent, and then they talked.
Okay, well, he didn't. That's not exactly what he said. Okay, hold on. So in the text messages, you've got to agree also that there's no express agreement in those text messages that he can pull her over.
Well, I think that objectively, there's enough that any mistake in how that was interpreted as a reasonable mistake and qualified immunity should apply.
Okay, well, you're dodging my question.
Okay.
So
Okay.
do you agree? Do you agree it was not an express consent?
Yeah, I agree. I gave you the hypothetical. The hypothetical didn't happen. She didn't actually say, "Please pull me over." Yeah, okay. You're right.
And so the next thing we got to look at then is was it close enough?
Right.
Right. And so would you agree with me that at best she was silent about whether he could pull her over or not, whether she agreed that that was okay?
Well, she could have not responded at all, but she did. She gave him the mile marker number, and she the next day said she wasn't sore about it. So I don't think
the next day is sort of post hoc reasoning, isn't it? I mean,
well, I think it objectively shows
consistent with what her attitude was the day before.
Well, I think it's consistent, and I think it shows what she was thinking the day before. It's an objective record of what she was thinking at the time. Sure.
I mean, a reasonable jury could determine that her statements from the next day were an attempt to try to get him to leave her alone and not, continue pestering her. If she just said, "No, I'm not mad," whereas if she said, "Yeah, I'm pretty mad about it," then he might have made attempts to contact her to make amends.
Yes, Judge, that's correct. And the judge, in fact, specifically held that. He held that there was that a reasonable jury could conclude that there was a First Amendment or Fourth Amendment violation. But that's a different question of whether qualified immunity applies, because qualified immunity applies if the law does not put him on notice.
So if we agree, if we conclude as a court that there was no consent, that at best there's a fact issue as to consent, do you agree there's no qualified immunity?
No, because even if if you're going to go into the facts and basically make the conclusion, I think you still have to look at the possibility that an officer could objectively make a reasonable mistake. Could an objectively mistaken officer reasonably construe these text messages, even if a jury might conclude otherwise, but could a reasonable mistake happen such that this appears to be consent? I think that's all we need to get to qualified immunity.
Okay, so you want us to make that determination as a matter of law and not look at it and say, wow, this seems tied up with facts here on determining whether.
And I think more to the point is that even if she didn't expressly consent, the law did not put him on notice. The law was not clear that
he does not know that he cannot pull people over at night on a highway with his lights on without probable cause or reasonable suspicion. He does not know that.
Judge Shelby said the consent is not clearly established. There's only 3 cases that talk about consent in the context of these kinds of traffic stops.
But in answer to my question, does he not know that he cannot pull people over without reasonable suspicion or probable cause?
But he also knows that the Supreme Court has said that consensual encounters do not implicate the Fourth Amendment. That's an equally valid pillar of the law. You have numerous statements by the Supreme Court in this circuit that consent does not implicate the Fourth Amendment. So here he is faced with apparent consent, and you have this other Hornbrook principles that you need probable cause too. But
so it seems to me that goes to the question of whether there was a constitutional violation.
Well, it's the burden of
conceded.
Well, that the judge found that a reasonable juror could conclude there was a constitutional violation. That's a different question. They still have to prove their case.
You don't raise it on appeal.
Well,
you don't contend on appeal that there was no constitutional violation.
Well, we don't disagree that the reasonable juror could conclude. We believe if this goes to trial that we would prevail, that the juror would believe the more competent evidence that there was consent. So
fair enough, but as part of this appeal, you've not argued that there was no constitutional violation.
Right. We're not challenging the district court's conclusion that a reasonable juror, construing the facts in the light most favorable to Leyva, could find a violation. We're not disputing that.
Let me ask a question. I thought you were arguing that this was a prank, and it's not clearly established that a prank can't be a violation, or it's not clearly established that a prank could be a violation, but you're not arguing that.
We're not
You're not arguing that there's sort of that the lack of clarity.
No, we're not arguing about prank. No, he did say it was a prank, but it was a prank based on consent. It wasn't just
only that the officer could have reasonably thought that he had consent to do this.
And that the law did not put him on notice that he couldn't, that basically consent cannot even factor it all into the calculus. There are 3 cases. The district court noted there were only 3 cases involving consent and traffic stops. And Leyva did not even engage in those 3 cases on appeal. She didn't even take the district court to task and say, well, here's why this case applies or this one doesn't. So we believe that she's failed completely to meet her burden of persuasion on appeal by not engaging with the district courts.
But even on your theory that the officer could reasonably have interpreted her text messages as establishing consent, isn't that a jury issue?
Well, jury may ultimately be the ones to decide that. But what we're saying is,
well, if the jury is the one that ultimately decide that.
Well, I think let me try to phrase it this way, Judge. When you have text messages that on their face objectively give implied consent, that basically on their face they objectively could be reasonably mistaken as consent, coupled with the fact that there is not existing case law saying that consent never factors into the equation. What we're saying is that given both of those, there's no materially similar circumstances, and there's no obvious clarity. Yeah. There's no case law that applies with obvious clarity to this situation. Does Your Honor have a question?
Well, it just seems to me the jury should be the one to decide whether someone could reasonably interpret her text as constituting consent.
Well, I understand the point. I appreciate that. I think also, though, that courts can also make a decision on reasonableness too, and that these text messages speak for themselves, and that when faced with these text messages in an ongoing back and forth, this is not just something out of the blue. This is after the first ride along, which after she initiated contact after the first ride along a couple weeks before. So there's an ongoing relationship, clearly.
So do you contend that it was a valid police function for him to pull her over?
Well, to the extent that Mr. Sykes is saying that he was not acting under color of law in any of this, and therefore Section 1983 doesn't apply. I mean, I'm not sure exactly what point he's stipulating to in that regard. He was acting under color of law. That's what they alleged in the complaint.
Do you agree with that?
A police car, he turned the lights on. Yeah, he's a uniformed police officer.
So he was exercising a discretionary police function and turning on his lights and making a traffic stop.
Yes, you are uniformed in a marked car with lights. You initiate a traffic stop. Yes. And
okay, I guess I just sort of wonder how there could ever be consent to that. I understand that if a police officer walks up to someone on the street and starts talking to them, that could be a consensual encounter. But a traffic stop seems remarkably different to me. And I'm just not sure that it's consistent, that consent is consistent with a traffic stop. I mean, I don't know, absent an express statement by the person being pulled over, yeah, pull me over. And I'm still not convinced it's certainly not proper from a policing standpoint.
Well, and the district court agreed with you, Your Honor. District court said, I don't think you could ever really consent to a traffic stop, but it's a different question. Was it clearly established? The qualified immunity question is a different question. And if this court were to rule in this case, then yes, it would be beyond debate that you could never consent to a traffic stop, but it's not beyond debate now, even with the district court's order. There's no appellate decision from this circuit. There's no Supreme Court decision. There's no consensus of the other circuits. And certainly Leyva hasn't marshaled any cases from other circuits. She hasn't demonstrated case law from this circuit or the Supreme Court that would put the issue beyond debate. So that, again, that's a separate question. You can have a constitutional violation, but the law was not clearly established. And so prospectively going forward, everyone's on notice, but qualified immunity still applies in this case because it was not clearly established at this time. So we asked the court to find that Leyva has not met her burden to show the law was clearly established. The district court got it right. We asked the court to affirm. And if there are no further questions, then we will.
You're not going to argue the second claim?
I can argue, sure, Your Honor. The second claim, again, the 14th Amendment claim, it's not obvious when you have a back and forth like this, when there's no evidence from her asking him to stop, no evidence that she expressed that it was unwelcome. She never asked him to stop. She never told him it was unwanted. It was clearly a back and forth. She was initiating as much contact as he was. She was suggesting going to meals. So what we have, the Johnson case is what counsel's mentioned a moment ago, but the district court clearly distinguished the Johnson case as a magnitude difference of misconduct in that case. This case pales in comparison. This is some text messages. He hugged her one time, but unlike the Johnson case, there's no sexual assault. There's no asking for sexual favors in response to doing his job. There's no evidence that he sabotaged the towing contract.
Would a reasonable officer think that his conduct toward this individual was proper and within his duties?
Yes, yes, because she never said stop. She never said it was unwanted. On these, when you look at the text messages speak for themselves, it was a whole lot of nonsense.
We're getting down to she asked for it. Is that what you're saying?
No, I'm not saying that. But she didn't say stop. She actually initiated much of the conversation. She initiated some of the innuendo and the flirtatious conversations. And so our position is, on a whole, this was a mutually engaging relationship, text exchange, and the district court was correct.
It seems again a lot like the first issue that it becomes a jury question as to who said what to whom and whether or not there was some kind of ongoing relationship and that she consented to all of this. And we're here on qualified immunity, which to me seems like a bit of a stretch for this kind of a claim. But
well, again, what case put Officer Robbins on notice that this back and forth was unconstitutional in this context? And again, we say there is none. District court said there was none, and Leyva hasn't shown it. And we ask this court to affirm. Thank you.
Thank you.
Let me thank the court for doing this now and not making us wait a year to meet in person. Thank you.
You're welcome. Thank you for participating. The case is submitted. Thank you both. We'll take a 10-minute break at this time. When we return, we'll hear argument in Natural Resources Defense versus McCarthy.
Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Good morning, counsel. We're ready to hear argument in the case of Natural Resources Defense versus McCarthy.
Thank you, Your Honor.
From the appellant.
Thank you, Your Honor. May it please the court, Joe Bushyhead on behalf of the appellants. The district court dismissed this case with prejudice on a Rule 12b-6 motion on the narrow grounds that a decision to lift an off-road vehicle closure under 43 CFR section 8341.2a is in every circumstance mandatory, ministerial, and thus exempt from NEPA, the National Environmental Policy Act, as a matter of law. I will focus my argument this morning on why the district court's reading of the regulation was in error, but I want to start with the 12b-6 posture, and for two reasons. First, this court is not judging the reasonableness of BLM's decision under the arbitrary and capricious standard of review. This appeal presents a legal question of regulatory interpretation, and so the standard of review is de novo. Neither the district court nor the United States are entitled to deference for their interpretation of 8341.2 as exempting compliance from NEPA. The second procedural item I want to raise here is that the United States arguments on appeal in part 3 of its response brief, these are arguments that address the 2008 Richfield Resource Management Plan, or RMP, should be rejected out of hand. I do intend to address these arguments on the merits, but at bottom, they rely on facts, not on law, and they must be judged after production of the administrative record here. So with that, I want to turn to the heart of this case, which is the plain language of the regulation. And I'll start with the provision's mandatory language. Section 8341.2a uses mandatory language, the word shall, only twice. And in both instances, the word speaks to closure. In the first instance, the word speaks to the implementation of a closure. Quote, the authorized officer shall immediately close the areas affected. And in the second instance, it speaks to the maintenance of a closure. These lands shall not be opened. The reopener provision, on the other hand, states that BLM must maintain a closure, quote, until the adverse effects are eliminated and measures implemented to prevent recurrence. And this provision preserves BLM's discretion for two reasons. First, there's no mandatory language. We see the district court placing emphasis on the word until, but the word until is not itself mandatory. It's a conjunction, a type of function word. So its meaning depends on the words that follow.
Well, isn't it though a trigger? Can it be read as a trigger? You do this until X, and then when X happens, then it changes.
It can be read as an automatic trigger when the word is followed by something like a date certain or a specific time frame. Then until, right, were the regulation constructed that way, the closure would lift automatically. But here, until points to the discretionary actions BLM must take before it can lift a closure, which is really the second reason why BLM has discretion here. By its plain language, BLM cannot lift a closure until it takes action. The agency must eliminate adverse effects from OHVs. The agency must implement measures to prevent recurrence of those effects. These measures are left open-ended, discretionary, and they are part and parcel of BLM's decision to lift a closure. They are provided for in the text of the regulation. The district court really made two errors in reading this reopener provision. The first was to presume, for purposes of regulatory construction, that BLM had already completed the discretionary measures.
Let me stop. Let me back you up for a minute, because I needed to get to some language here to ask you about. So when you were telling us about what had to happen, you were saying that BLM had to cause the adverse effects to be remedied and things like that. It doesn't say that. It says that BLM has to close it when a certain determination is made. And it says when that when the adverse effects are eliminated and measures implemented to prevent recurrence, that it ends. But it doesn't specifically place every burden on BLM, at least textually, does it? I mean, you might be able to read it that way, but it's...
I think this is really only an issue that comes up because the regulation, the reopener provision, is written in passive voice. It sort of invites that question of who is to take action here. But BLM, as the land management agency, has the authority, has the control, regardless of whether BLM is in fact the agency taking measures. The agency has control when it comes to remediating the effects from off-road vehicles. So I think
is it your position that BLM would have to, in order to make the determination that it could be opened back up, they'd have to do full EIS?
No, Your Honor. That's an open question. That's a factual question at essence, that we would judge on production of the administrative record on remand. The agency would have...
So your position for our purposes is just that the authorized officer doesn't get to just make this determination, that it opens back up.
That's right. There's more than sort of this passive evaluative action here. The BLM is itself either taking action itself, which I think is the situation that would actually occur on the ground, or at least has control over what the lifting of the closure looks like, the measures taken.
Okay.
And that's...
So let me back you up even further. So in order to close the area, all that's required there, though, under your reading, is the authorized officer to say, hey, we need to close this. And so the authorized officer can then close it, but the authorized officer then doesn't have the authority himself to just open it back up. To make the determination that the statutory or the regulatory condition's been satisfied.
Right. And I think that really comes from a reading of this court's case in Carpenter, where that case involved the front end question of when and how BLM would implement a closure. That's not an issue here. And I'll note, too, that the Carpenter case left the question of whether NEPA applies on them to the implementation of a closure. It left that question unresolved. We're really focused here on the lifting of a closure, really in isolation.
Well, is that fair, though, to say it's in isolation? I mean, you have the resource management plan. That's the backdrop, it seems to me, of this case. And to achieve that, as we all painfully know, there has to be a lot of procedures, particularly environmental studies, that go on to say what will or will not happen in this particular area. And at that point, when the plan was promulgated, it was determined that this area would be open. So don't we rely and fall back to that? That's basically the bedrock that we start from in this case.
Well, Your Honor, I come back to the 12b6 posture here and the fact that we don't yet have an administrative record. This case was decided on this pure question of law, on regulatory interpretation. And that's really the touchstone. But to take...
Again, to answer my question, don't we have as a backdrop in this case the resource management plan? And that told us the area has been studied environmentally, and it has been determined that it is fine to open these roads up. So that's where you start. It's okay to have open roads here.
Well, Your Honor, I don't think that's a fair reading of the RMP, and I think there's a legal problem with that as well. As a factual matter, the Richfield RMP designated lands as open, yes, but it kept the closure in place, quote, regardless of the OHV designations. It required a separate decision to lift the closure after BLM completed the discretionary measures necessary to lift a closure to protect the right fish hook cactus here. And it made the area's open designation subject to amendment. These are at pages 82 and 87 of the appendix. The last point really gets to the legal problem that we face here, and that's that even after issuing an RMP, BLM retains discretion by law to amend the open designation to either limited or closed. That's provided for in both the broad land use planning regulations, the Part 1610 regulations, and also expressly for OHV designation in 43 CFR 8342.3 that expressly reserves BLM's authority to amend, revise, or revoke land use plans. And that question of, here it's not a question of if, of whether BLM actually did revise the land use plan or amend the designation. It's that BLM had the choice. BLM had the option. It had this discretionary path it could take.
Let me get at this a different way. It's a follow-up to what Judge Briscoe was pursuing, I think. What sort of EIS are you seeking here? What do you conceive of as the EIS? And why wouldn't that just be duplicating what was done for the RMP?
Certainly, Your Honor. There is no, I'll return to the point to start, that there is no requirement. We don't know yet whether BLM needs to prepare a full EIS.
Don't tell me I'm not asking for that. That's what
sure.
Yeah. So what do you conceive of that? What would it do that's not duplicative of what had already been done under the rule of reason?
The short answer is that there is no way the 2008 RMP EIS would have been able to evaluate the efficacy or the effects of off-road vehicle use with measures BLM put in place in 2019. There's a temporal gap. But I want
challenging that, then you can challenge the opening order under the Administrative Procedure Act. That's not a NEPA claim. You're just saying that there needs to be review of this decision to open the road. And that's fine. And I think you could do that under the APA. Maybe I'm missing something. I'm asking what the environmental impact study would say that essentially goes beyond that. That wouldn't be duplicative. When the RMP said open roads are okay here after an environmental impact study. I'm having a hard time seeing what you want. That's not a repetition.
Well, to the extent we're viewing this through the rule of reason, that inquiry needs to happen. What would we be looking at? That inquiry needs to happen after production of the record. Fundamentally, the argument that BLM, that the United States is making here, that the 2008 Resource Management Plan already looked at the effects of lifting a closure, which is specious because we don't yet know, we did not know, the BLM did not know in 2008 what measures would be in place, what the actual effects of lifting the closure would be with the parameters of the closure order in place. The question of the rule of reason is really one that we need to look at. This argument of the sufficiency of the EIS is one that needs to be looked at on remand after production of the full administrative record.
To make any suggestion of what this is all about?
Oh, certainly. It's about the efficacy of the measures.
The measures does not require an EIS. That just requires a review on the administrative record under your usual APA procedures.
Right, and I'd return to the 12B6 posture here. We don't yet have the administrative record. And I'll note too that the way in the District of Utah, these cases proceed under Rule 7-4 for Olin House style cases. The record is produced and there is we would have the chance to, at the very least, amend our complaint on review of the record to challenge the merits of the decision. This case was dismissed on this issue, on the NEPA claims alone, without the chance to amend. This was really the first crack.
Do you see a distinction between the agency's exercise of discretion and the authorized person's exercise of judgment in determining whether the measures have been effective and the roads can reopen? And I'm thinking of the Sixth Circuit case. I think you cited it in your brief. I mean, how do you distinguish that reasoning?
Right. Well, certainly, Your Honor. And this really goes to this timing problem. With the question of when to judge discretion, I think first and foremost. a central question for this case is, when do we judge discretion for the purpose of NEPA? And it applies to proposed federal action. So we're looking at discretion before the point when
they're not proposing anything, are they? They just do it.
Well, there's a NEPA regulation on point here, 40 CFR 1508.23, that sets black letter law on this question of when the agency must evaluate discretion. I see I'm out of time. If I may finish my answer here.
Please answer the question.
So proposal, and I'll go to the definition here. That stage of the development of an action when an agency has a goal and is actively preparing to make a decision on one or more alternative means of accomplishing that goal, which means that discretion must be judged at the point when BLM has the goal of lifting the closure before it settles on and completes the discretionary component of this decision-making process. The district court here, and I think Your Honor's question really hinges on a problem with the district court's reading, that the question here, the district court judged discretion not at the proposal stage, like it must under NEPA, but at the very final implementation stage. And I hope that answers your question.
Thank you.
Thank you. We're ready to hear from the appellee.
Yes, thank you. Andrew Birney for federal appellees. May it please the court. I'd like to start actually on an area where I think Mr. Bushyhead and I agree, actually. And Judge Hartz, I think this goes to your question as well, and that's that the merits here are not before the court. Plaintiffs have not only not challenged the 2008 RMP's designation of this area as open to OHV use, they also haven't challenged the substance of the merits of the 2019 closure lifting action. And they could have done that, and frankly, perhaps they still can. And what would happen then is the question would be whether the decision by the agency to lift the closure was contrary to the regulation, wasn't supported by substantial evidence. The APA standard, as you know, Judge Hartz, so the question for the court in this case is not the merits of the decision, it's whether BLM, having determined, which we think is taken correct for purposes of this appeal because they don't challenge the substance of it, having determined that the adverse effects had been eliminated and measures put in place to prevent recurrence, whether lifting of the temporary closure at that point was mandatory. And the language of the regulation, we think, is clear that it is. And Judge Briscoe, you mentioned that doesn't until function as a trigger. And we think that's exactly what until means, both in this regulation and in ordinary speech. Mr. Bushy had referred to a limitation on that to a point in time that's certain, but I don't think that's how until works. If I say, for example, that I'm going to stay at a job until I finish a brief, everyone would understand that as meaning I'm going to leave the job when the brief is completed, even if I don't know exactly when it is. And so the language of the regulation is clear, and that language also conforms the regulation to the FLIPMA and to the Supreme Court's decision in Norton v. Sua. And we do think the RMP's designation of this area is important. BLM considered this issue in 2008. It performed environmental analysis, and
don't you though have the problem of the lapse of time? I mean, that's a long time ago, particularly when you're talking about fragile areas such as this, and also plants and animals in this area.
Well, there is a lapse in time, Your Honor, and of course there is an option. Plaintiffs could petition for amendment of the RMP on account of changed circumstances, but until an amendment, but as the Supreme Court made clear in the Norton v. Sua case, until an RMP actually is amended, BLM is obligated to comply with it, and it's just any decisions that it makes that are inconsistent with it can be set aside as contrary to law. Plaintiffs' theory of this regulation is really a one-way ratchet. Really inverts that burden. And the other thing I would say, Judge Briscoe, is again, we don't dispute plaintiffs' ability necessarily to challenge this interpretation under the APA, not this interpretation, this temporary closure order, as contrary to the regulation. They just haven't brought that challenge here. And the one thing I also want to add, Judge Carson, I think you were asking about the standard for imposing a closure order. I think it's important to note that just as that, although the decision to lift a closure order requires a measure of judgment on the part of the agency, we cite cases for the proposition that judgment under statutory or regulatory criteria doesn't equal discretion for NEPA purposes, but so too does a decision to impose a closure order. I mean, BLM had to determine in 2006 that there were adverse effects being caused by these OHVs. It had to identify the area where it was causing these adverse effects, the types of vehicles, and impose the closure. I mean, it was the same level of judgment. That there was no public comment before it imposed the closure order. The agency didn't perform NEPA review. We think that was perfectly proper, and plaintiffs agree with us for that matter. But what they're asking this court to accept, and what the district court properly rejected, is this idea that the regulation functions that the regulation functions as a one-way ratchet. They say that explicitly on page 3 of your brief.
If you're looking at harms to environment, I can see their point of view. I mean, closure of the road would always be a positive for the environment, whereas opening the road would likely not be.
Right, Your Honor. Well, I guess I say a couple things about that. First of all, I mean, we think the way the regulation is drafted, that the agency's decision to lift a closure is just is non-discretionary once it makes the determination, just like imposing one. But again, I don't mean to repeat myself, but they can challenge that. Mr. Bushy criticizes the district under the regulation via an ordinary APA challenge. I mean, Mr. Bushy criticizes the district court for dismissing this case on the pleadings rather than requiring the production of an administrative record. But I mean, if you look at the complaint in this case, it only mentions the regulation once in the legal background section. The complaint is very clear that this is purely a procedural challenge to claiming that NEPA review was required. And that's a legal claim that we think is just wrong under this regulation under FLPMA. Had they brought a substantive challenge claiming that this was arbitrary and capricious because the agency made an incorrect determination under the regulation, we assume that the administrative record would have been produced and the case would have been litigated that way. And again, perhaps they can still bring that claim, but that's not the claim they chose to bring. Happy to address any questions the court might have on any particular issue.
I was just curious, what is the longevity of an RMP? Do they just go on forever, or?
I mean, no, not necessarily, Your Honor. I mean, there is a process. There is a process for amendments. But until the RMP is amended, the agency has to comply with it. And Mr. Bushy had referred to the RMP. I think we say this in our brief, and I think this is important. If you look at, I think page 82 of the appendix has the relevant language, although it's reproduced elsewhere. It keeps the temporary closure in place, but it makes clear that the temporary closure will be in place only until the regulatory criteria are satisfied. So I don't think the RMP really, the RMP only underscores what the text of the regulation in FLPMA itself made clear, which is that the temporary closure, which is intended to be temporary, is to be lifted once BLM makes the determination that the regulation requires. If there are no further questions, we would ask the district court's judgment be affirmed.
Thank you. Any rebuttal?
Yes, Your Honor, if I may have the time.
Sure. How about a minute to wrap up?
Sure.
You'd gone over.
Oh, absolutely, and I appreciate that. I really want to come back to this point of timing, this question of the determination to lift a closure being separate from the measures that BLM puts in place when it actually lifts a closure. The discretionary component here, the measures that BLM actually puts in place, are part and parcel of the decision to lift a closure. They can't be segmented out in the way that the district court reads the regulation, the way that Mr. Birney argues now. I also want to just quickly address the point. This is a factual matter here. We're not talking about one specific road. We're talking about 5,000 acres of essentially desert badlands on which OHVs, off-road vehicles, can travel cross country. Their off-road vehicles are currently allowed on designated roads in this area. And with that, I thank the court for its time and ask the court to reverse and remand.
Thank you. Thank you for your arguments this morning. Case is submitted. Our next case for argument is Gerson, Logan River Academy.
Good morning, Your Honors, and may it please the court, Alan Moritzen for Appellant Samantha Gerson. I'll endeavor to reserve 4 minutes for rebuttal. When plaintiff was 15 years old, 2 employees of Logan River Academy showed up at her school and transported her against her will to Logan River Academy in Logan, Utah. Over the next
Let me stop you there. Have you adequately pleaded that? Shouldn't you have to say some things? What does it mean against her will? Was it her parents wanted her to go there and they had arranged for transportation? There's nothing in the complaint that really provides the information we need to know that this was a kidnapping, essentially.
Well, and I think, just to be clear, the allegation of the complaint is that it was against her will.
Yeah,
and
well,
as a fifth,
explain a little bit about what that means. It might have been that it was her parents' decision. That would be against her will. That has different consequences from someone from the academy just coming and kidnapping her.
And I wouldn't dispute that, but the point is that we're alleging this from the perspective of a 15-year-old girl.
Well, it has legal consequences, whether it's her parents or somebody else, doesn't it?
Well, I'm not sure what legal consequences you would have.
Well, you make the point. It's really the only colorable point you have, I think, that California law should govern because she was kidnapped from California to start this whole process. And that depends a bit on what you mean by kidnapped or taken without, against her will. So you don't include any factual allegations here regarding that. And I'm curious about that because there's other stuff in the record that suggests this was far from a kidnapping.
Well, I want to be clear. We include very clear factual allegations about the involuntary nature of the transport, in the sense that she showed up at school. There were 2 agents from Logan River who approached her in the back room. They told her that this could go the easy way or the hard way, that they might need to place her in handcuffs if she resisted. And then they took her on an airplane, accompanying her the entire time.
Doesn't it matter how this came about? Doesn't it matter how they came to think that they could handcuff her, whether this was a mental health commitment or something like that?
It might ultimately matter, but in terms of, and it might ultimately depend on what discovery shows. But remember, this was granted on a 12B6 motion.
But she knows. This is a case where she doesn't need discovery. She knows these facts better than the defendant, or at least as well as the defendant, wouldn't she?
Well, then, so the defendant can discover those facts. But the point is that, well, my only point is what she has alleged is sufficient to draw the factual conclusion that this was against her will.
Right. I think what Judge Hartz is getting at that you may not be answering is that saying it was against her will is not enough. And perhaps, I'm not staking that position out. I'm just saying that that's the question. Maybe it requires more. Not only was it against her will, her parents and no authorities authorized it. If her parents authorized it, which is not part of your complaint, one way or another, it could have a drastic impact on your case. Do you agree with that?
Well, I think it could influence which law applies. I don't know if I would agree with the term drastic, only in the sense that, I mean, what we're really asking about, we're asking about a choice of law inquiry.
Okay, so if it impacts whose law applies, if it's Utah, you lose.
That's true.
So it's drastic.
Well,
so it is drastic.
Well, it's drastic only if Utah law applies if the parents authorize the transfer.
Right, and I guess what Judge Hartz is getting at is, did you need to allege affirmatively that not only was it against her personal will, that there was nobody with authority over her that authorized it either?
No, I don't think so. I mean, I think we have to create a colorable question, a plausible claim based on the underlying circumstances, based on the fact that she showed up at school and was taken by these two individuals. The district court, I'm not aware of any law that says the district court can assume that this was authorized by someone else. And it certainly formed no part of the court's analysis to say that it was authorized by someone else.
Well, let me ask you another question.
Okay.
Doesn't seem like we're getting anywhere on that one. So let me ask you another. In the case of in the situation where a case is transferred from one state to another, where's the forum state?
The forum state is the transferor court.
So your position is the forum state is California?
It is.
Okay.
And
is your co-counsel going to agree to that? Is that conceded?
It is conceded under Ferens versus Deere that a transferee court applies and I don't want to get caught up in the terminology. A transferee court applies the law of the transferor court, and so the transferor court is treated as the forum in that instance.
Okay, so does your court use that language? Because I've not found a case that says the forum state, because it makes a difference which state is the forum state. I've not seen a case that says the forum state is the transferor case. You may have a great argument that you have to have a choice of law analysis and that the law of the transferor state is going to apply, but it can be different when it comes to statute of limitations.
Well, and that's what I'm saying, maybe the terminology, the cases that I'm aware of, and includes Ferens versus Deere and other cases that talk about when a case is transferred under 1404A for purposes of convenience, and the transferee court treats the transferor court as the forum, as the controlling court, in essence. We're sitting in that court's shoes, we're applying that court's law. And so in every respect, I think it is the forum for purposes of a choice of law analysis.
Okay.
In terms of analyzing the choice of law, both sides agree that the laws differ here, that there's a genuine conflict. So the only question is which state is going to suffer a greater impairment by application of the other state's law. And you perform that analysis not by assessing which state has the better or worthier policy, but who has demonstrated a stronger interest in their law, and which state should be allocated the predominant lawmaking authority. This is under the governmental interest analysis.
So do you agree that can differ based on whether the conflict of law is a procedural or substantive law?
I don't, and only because California law has rejected that distinction.
Okay, well, let's throw that out the window. Do you agree that it can differ based on whether it's a statute of limitations issue or a substantive law issue? i.e., can you recover in both states for the type of action you're bringing, or as compared to whether you filed on time?
Yeah, I don't think that there is a distinction. I know that there are some states who have tried to cabin statute of limitations issues under the choice of law analysis, but I don't believe California is among them. California does not differentiate between procedural and substantive laws in terms of analyzing whether the laws conflict and in determining which law should govern. And so I think with that established as a premise, it becomes quite clear, analyzing the California Supreme Court's decision in McCann and offshore rental and Castro, that whether the plaintiff's presence in the non-California state is voluntary is a critical factor. And just to return briefly, we have alleged sufficient facts to draw the plausible inference that Samantha's presence in Utah was involuntary. If additional facts come forth at some point, we're not arguing that those facts could not be introduced as part of a renewed motion to dismiss. But based on the allegations in the complaint and the admissions made by Logan River in response to the evidence submitted in support of our opposition, we know two things. One, that Samantha's presence in Utah should be treated as involuntary. And two, that Logan River actively solicited and advertised its business operations in California. And if you read Bernard and Kearney, that matters. It matters which of the two parties, the plaintiff or the defendant, reached in to the other party's state.
Do we have those allegations of advertising and reaching in to the other party's state? Is that within your complaint?
The transacting business or the advertising and solicitation is not in the complaint, but there's also no law that we're aware of, and Logan River has certainly not cited any, that says you not only have to plead a plausible allegations to support your cause of action, but that you also have to plead allegations related to a choice of law analysis. But
if you're asking for the district court to consider facts beyond the four corners of your complaint, and we're looking at a motion to dismiss, doesn't this have to become a motion for summary judgment?
Well, and we would welcome that, but the fact is that the court didn't treat it that way. You see across the country, you see courts often reluctant to resolve choice of law issues at the motion to dismiss stage because it requires factual development. You have the Ninth Circuit's decision in Cooper that says, hey, the district court has everything it needs to make this determination. You have the First Circuit's decision in Foisey that says there's holes in the record. We need further factual development before we can make a determination about the choice of law. But there's none of those cases suggest that for purposes of a complaint, that if you have not alleged every fact related to the choice of law analysis, that you're out of luck. Yeah. You are typically given...
I get your point. You're saying it's not your problem. It could be an error on the part of the court.
Exactly right, a procedural error. Right. We think the allegations in the complaint combined with the essential admissions of Logan River about their advertising and solicitation of business in California is enough to rule in our favor, just as a matter of law, that California law governs. But in the alternative, we would welcome the court reversing the district court for further factual development on the choice of law analysis. And if there are no other pending questions, I'll reserve the last minute of my time.
Thank you.
Thank you, Your Honors. May it please the court. I am Molly Loy, appearing on behalf of Logan River Academy, the appellee. This appeal involves a relatively simple issue. What statute of limitations, California or Utah, should apply to torts that occurred within the state of Utah and which are alleged to have been perpetrated by a Utah corporation and its Utah employees? It is the position of the appellee that the Utah District Court correctly answered this question when it applied the Utah statute of limitations and dismissed this action accordingly. The appellant has argued in briefs and now before this court that despite the location of the alleged torts and the alleged tortfeasors, the California statute of limitations should be applied based upon the allegations that Ms. Gerson was involuntarily in the state of Utah, that Ms. Gerson was a California resident, and that Logan River Academy allegedly advertised in the state of California and solicited business within the state of California. I'll first address why the appellant's arguments do not sufficiently give rise to the California statute of limitations. And then I will address the factors that make it clear that the district court ruled correctly in applying Utah law in dismissing this action. Regarding the allegation that Ms. Gerson was involuntarily in Utah, the factual allegations of the complaint established that she was approximately 14 or 15 years old when she was enrolled at Logan River Academy. Accordingly, while Ms. Gerson, the minor appellant herself, might not have wanted to attend the school, in order for her to have been enrolled in this school factually for an entire year, as she was, someone on her behalf, a legal parent or guardian, enrolled her in the school and paid for her to be there. Logan River Academy is not a public institution, therefore tuition was required. If this hadn't happened, someone had not enrolled her, she would not have been able to attend the school. She quite simply was not kidnapped, as is claimed, and taken to Utah against the will of those responsible for her legal care and custody. Also, this is an action for childhood sexual assault. This is not an action for kidnapping or involuntary transfer. The appellant's complaint here contains causes of action for childhood sexual assault, which are alleged to have occurred at Logan River Academy in Utah, negligent hiring of teachers and staff at Logan River Academy in Utah, the negligent supervision of teachers, staff, and students at Logan River Academy in Utah, the negligent education of the plaintiff regarding the dangers of sexual assault at Logan River Academy.
I think we have that side of the argument pretty well in hand. The question for us on the conflicts of law is to measure the interests of each respective state and determine which law should apply.
Thank you, Your Honor. The appellee's position here is that Utah has a greater interest in deciding this action based upon the fact that we're dealing with a Utah corporation and its Utah employees, and that every single tort alleged in the complaint occurred within the state of Utah.
Let me interrupt. First, one quick factual question. There's never been an allegation that she was unlawfully removed.
That is correct. That simply that she did not want to go. Correct.
Both you and opposing counsel have spoken in terms of the interests of the state governing the choice of law. And that sounds like whether the California cares more about kids being abused than Utah or vice versa. And I don't read that as the test for choice of law. I read it as, I'm reading from the McCann decision, the California Supreme Court. The process can accurately be described as a problem of allocating domains of lawmaking power in multi-state context by determining the appropriate limitations on the reach of state policies as distinguished from evaluating the wisdom of those policies. Emphasis is placed on the appropriate scope of conflicting state policies rather than on the quality of those policies. So I don't think it has anything to do with, under California choice of law, with the strength of the feeling of each state regarding how much one should punish this type of conduct, but just a determination by the California Supreme Court of which state should have the lawmaking power in this circumstance. So you put it in terms of policies, I thought, and you're kind of nodding your head. You agree that the McCann formulation is what we're supposed to apply, or do you disagree?
No, I do agree. I think McCann has a lot of wonderful language in it that can help guide this court in deciding this action. I know that the appellant has cited to the McCann case. I think it strongly goes in favor of the appellee's argument here. The
that
court
was
in
the limitations case, was it not?
Correct. And the court in McCann had some things to say that are also very on point for the issues we're dealing with here. You just read a quote from the case, and I would like to do the same here. On page 100 and 101 of the McCann decision, the court said, and I quote, "When the law of the other state..."
Wait. You're quoting pages 100 to 101. That doesn't sound like that's a cite from Pacific Third.
Oh, it is. It is. Oh, I'm sorry, Your Honor. It is not. You're correct. You know, I don't have the Pacific Third site.
What are you looking at?
You know, I am not sure. I have that written down, but it's not the Pacific Third site.
I think it's the Cal Reporter.
I think you're correct. Yes. And the court in that quote says, "When the law of the other state limits or denies liability for the conduct engaged in by the defendant in its territory, that state's interest is predominant." So when we're talking about what state has a greater interest in having its laws applied to an action, McCann makes it clear that Utah would in this case, because in Utah, the statute of limitations that is controlling is more limited than it is in California. And because based on the holding of McCann, a state has a greater interest in controlling torts that are alleged to have occurred within that state's borders, which is exactly what we're dealing with here.
What do we do with the fact, if we can consider it as a fact, that there is advertising by the Academy in California?
The advertising arguments, it is appellee's position, fail on several fronts. The first is that they weren't pleaded in the complaint. There are no allegations in the four corners of the complaint that Logan River Academy advertised in California or solicited business in California or did anything in California.
How do we get those facts into this case? Was that the response to the motion to dismiss?
It was correct. It was a response to the motion to dismiss that was filed before the United States District Court for the Central District of California, the court that ultimately transferred the case to the Utah District Court.
Yeah, okay. So that information in a pleading was before the district court here in Utah.
It was not in the complaint, but it was in an opposition or a response.
Yes, in a pleading. Okay, thank you.
Correct.
Did the district court decline to consider it?
You know, it didn't specifically state. I think that it could have very likely considered it. What the court held its hat on here was that all of the torts that give rise to causes of action in this case are torts that occurred within the state of Utah. The solicitation of business, there's no allegation that had anything to do with this particular case.
The test that I think we're supposed to apply is determining the appropriate limitation or reach of the state's policies. Did the district court in this case look at that analysis at all?
The court did. The court examined the choice of law issue appropriately in terms of the law, and it did weigh which state's policies would be more impacted based upon which state's laws were applied. And both district courts, the Central District in California and the Utah District Court, felt that the state of Utah had a greater interest in having its laws applied to this action.
Did the district court here identify any interests on behalf of California in this case?
Yeah, the main issue here is that the minor plaintiff, was a California resident at the time that the assaults occurred. But on the issue of residency, there aren't any cases that have been cited here by the appellant that residency alone gives rise to that state's laws. In every case where residency has been discussed, it was residency and another factor, such as where the tort occurred, that gave rise to the laws of that state.
Do we look at the extension of statutes of limitation in California for this type of claim that is sexual abuse of children? Do we look at that state interest?
We do, yes, and that's addressed in the appellee's brief. The statute of limitations—
Was it addressed by the district court?
I believe it was not thoroughly. The district court did address what interest the state of California had in protecting its residents. And ultimately, in addressing this, the court said that while a state does have an interest in protecting its residents, that interest is not absolute, and a state's reach isn't infinite.
Let me explore something with you. And that is, I'm going to read you a short blurb from the restatement second of conflict of laws. It says, a state has a substantial interest in preventing the prosecution in its courts of claims which it deems stale. Hence, subject to rare exceptions, the forum will dismiss a claim that is barred by its statute of limitations, including a borrowing provision making applicable statute of limitations of another state. So that statement seems to me to suggest that there's a difference in a conflict of law analysis when you're dealing with statute of limitations as opposed to substantive law, and that a state's interest in applying its own law is exceedingly high when it comes to statute of limitations. Do you agree with that, number one? And do you know of any California case law that supports that idea?
I would agree that a state has a high interest in applying its own laws, which I think supports the application of the Utah law here. Utah has an extremely high interest in having its statute of limitations applied to alleged assaults that occurred in Utah. As for
don't you have the same interest and limitation, if you will, for California?
I believe California would have an extremely high interest in having its statute of limitations applied to claims that occur in California. And the provisions of—
how about to its resident?
Well, its residents. It doesn't have unlimited reach to protect its residents from everything. And there is not a single case that supports that proposition. When a resident leaves a state, the laws of its home state don't protect it from everything. And in fact, statutes of limitations are not designed to protect a resident. They are designed to prevent the litigation of stale claims. What's designed to protect residents are the laws of those states. But
just like McCann was statute of limitations for asbestos.
Yeah.
California had a longer statute of limitations, but they didn't apply it when the plaintiff, who was from California, was exposed in Oklahoma. Am I correct about that?
McCann he was an Oklahoma resident at the time that he was working in Oklahoma and at that time he was exposed to asbestos. Years later, he moved to California, and then several years after that, he was diagnosed with mesothelioma and attempted to sue. So McCann is a great example of a case where it wasn't residency that made the turning point here for the court. The McCann court looked at where did the tort arise that gave rise to the litigation, and that was the—
There also the consideration in McCann that you have a plaintiff here that's moving around, and that we're not going to let him bring actions in any state that he happens to land in, particularly one with a very long statute of limitations.
I would agree with that. I think statutes of limitations and applying the law of—
You don't have a resident in that parallel here. You don't have our plaintiff isn't moving around and choosing a forum.
That's correct. But every other case, including offshore rental and Castro, all the other cases that have been cited where plaintiffs weren't necessarily moving around, the case of Bernhard, all of these ones cited by the appellant and the appellee, where residency was discussed, the key issue for the courts was looking at where did this tort arise that gave rise to the litigation. Residency was not a sufficient basis by itself to have the laws of that state apply. I see that my time is over, and if there are no further questions, I would ask the court to affirm the ruling of the district court.
Thank you.
I would just make 2 quick points in rebuttal. First, on the question of voluntariness, most of what we heard was extra record evidence that's not before the court, that wasn't included in the complaint, that wasn't included in any of the submissions, specifically about guardianship, about the circumstances under which Samantha could have ended up at Logan River Academy. And that only illustrates the problem with making a fact-dependent determination of voluntariness at the 12B6 stage. The second point I would make has to do with McCann and Bernhard. McCann, yes, has that language, but the facts are critically different. And the California Supreme Court has made clear that it's a totality of the circumstances analysis. And in that case, you have an Oklahoma resident who lives in Oklahoma, who grew up in Oklahoma, who suffers the tort in Oklahoma and then moves, which is critically different than the case here. And the last thing I would say is about Bernhard, which is very similar. A Nevada tavern owner advertises its business in California, leading a California resident to voluntarily leave and drink in Nevada, and that's where the tortious conduct occurred, and then is involved in a car accident on the way back home, and the court determines that California law applied. For these reasons, we ask that you reverse the district court and remand for further proceedings.
Thank you. Thank you both for your arguments this morning. The case is submitted. And with that, the court is adjourned. Our next session for the court is 9 a.m. tomorrow morning. Thank you.
Court is in recess until 9 a.m. tomorrow morning.